we're back in order. Madam Clerk, is there anything you need to say other than to announce that we met with
Mr.
the
Wright.
attorney, and do you wish to continue to allow him to say something, or announce something, or do you guys want to announce something? Is there a motion to adjourn? What's your pleasure?
He's number 3 on the agenda,
Yeah,
so
so
we
he
are now
can-
at a closed session, and he is, are you moving on to agenda item number 3, is that correct?
Yes.
Y'all need to move and vote to come out of closed session.
Well, that's what I'm asking the board, what the pleasure is.
Asking the clerk.
All right, we need a motion to come out of executive session if you don't have anything else. You
So
want-
moved.
Is there a second? All in favor say aye.
Aye.
Opposed say no.
You're buzzing.
We're out of session, and we're now throwing the ball to you, sir.
All right, thank you, Mr. Mayor, and for those who don't know, my name is Clark Wright. I'm an attorney with David New Bern, and I've been practicing law 34 years now. And, you know, just like doctors, we always practice, you don't ever get there. Specializing in environmental issues, and for the last quarter century or so, specifically specializing in coastal issues.
Excuse me, can I interrupt, please?
Yes.
I'm very sorry. There's a report they're going to review, correct?
Yes,
We have copies. Does any objection to making this available to the public so they can follow along?
I was actually looking for a copy.
I've got 4 or 5 here if you want.
Can we,
That'll do it.
sorry to interrupt, Mr. Wright. Just hit it, see if it's on. No, hit the, there you go, there it's on. See the red light?
Yeah,
You're hot.
I think the Bluetooth is now connected.
Okay, great. Sorry for the interruption.
That's quite all right. Anyhow, the bottom line is that the board in December voted to retain my services to try to take a more in-depth review and analysis of the pending potential terminal groin project in the context of maybe larger shoreline erosion control or beach protection, beach and inlet management issues, and to try to give the board information specific to what their concerns and needs are to make better decisions on the extent to which the town wants to continue to pursue or not pursue the proposed terminal groin project for Lockwood Folly Inlet. And in connection with that, and with a lot of help from David Hewitt, who I really do want to thank, and Heather too, I did throw together, it might be the right word, or David and I and Noel too, put together just a fact and status sheet for you to potentially take a look at, because there are a lot of moving parts to this. And the fact sheet is sort of self-explanatory in large part, but I wanted to highlight a few things. Right now, the major permitting process that's going on is with the U.S. Army Corps of Engineers under what's known as Section 10 of the Rivers and Harbors Act of 1899 and Section 404 of the Clean Water Act, a much more modern statute passed in the 60s and 70s and amended since then. And basically, you're asking the federal government for permission to place a structure in so-called navigable waters of the United States that are regulated and controlled by the Corps of Engineers as the primary lead federal agency. But in classic unfunded mandate fashion, the Corps then tells the town to pay for everything needed to put together the environmental impact statement. And you can see there some listed bullet points based on the information that David Hewitt helped gather for me and for y'all. The town has spent over $637,000 on various components of this project over the past 5, 6, 7 years. The two largest items being the consultant, Dial Cordy, who's drafting the document. Even though ultimately by law it's the Corps' document, they make the town pay for somebody to draft it for them, and then they do various reviews and send it back with comments for revisions, et cetera. And then the other rather interesting larger figure is for outside legal counsel from a different law firm that was retained by the town many years ago to help promote or push forward the terminal groin application process. I think I view my role as to kind of be, if you will, you're facing major surgery and you want at least a second opinion. And so I view the basic mandate that I've been given from the Board of Commissioners is to take a hard look at whether this particular option for shoreline erosion control purposes is the best or an appropriate option for the town to continue forward with or not. There are multiple points in time at which the board can make decisions to continue forward or not. The number one obvious power the town has is the power of the purse string. The board can stop funding any portions of the project at any point in time. But there are also legal issues tied to these various permitting processes, and that's one reason we were in closed session for so long, is there's a lot of complexity to that. And I was attempting to brief the board members on various aspects of that. Under actions to date, the USACE, that's the Corps, U.S. Army Corps of Engineers, they are the lead agency on these permits that are currently part of what has triggered a long-running environmental impact statement review process. The town's website has some excellent information links, including the entire EIS. If you really need to get to sleep at night, just pull up that document and start reading any of the appendices. The final version of that document is expected to be issued by the Corps within roughly 30 days. As I think some of the commissioners have wryly noted, we've heard that before. But this time I think they sort of kind of mean it. I believe that it's more likely than not, based on the conversations I've had with various regulatory officials, that the final document will actually be published in the Federal Register within approximately 30 days, although, as Patty rightly pointed out, that may assume no government shutdown. And, you know, that literally could be yet another X factor in that time process. Once the final EIS is published in the Federal Register, it'll obviously also show up in the town's website and in probably news releases. There is an additional final, quote-unquote, 30-day comment period required by the federal rules. And anyone can make comments on the final document, which will generally have a selection of the, quote, preferred alternative for consideration by the federal agency decision maker. So it's important to realize that after all this money and all these years, the final EIS is not a permit, and it's not a end to the process by any means. In fact, it's kind of a front-end loaded prerequisite to going further on the formal permit application processes. The main ones that apply here are the Section 10404 permits, where the Corps is the lead agency, and then the Major Development CAMA permit, where the Division of Coastal Management, or CAMA, is the lead agency. Once the EIS is out, those two processes will tend to run in parallel together at the same time. Based on a phone call I had with one of the Corps officials just this morning, he guesstimated that all of that, if the town continued forward with it, would probably result in a final record of decision, which would also serve as the final Section 10 and 404 permit approval, and likely the major development CAMA permit approval or issuance late summer or early fall.
I have a question.
Yeah.
Mr. So you said they could run concurrently. Do they have to? Can we control that?
It is generally difficult to separate them because there's actually a so-called 291 agreement between the Corps and Coastal Management to coordinate and cooperate on these types of major permit processes. I think that legally, and I have not thought about that issue till you mentioned it, it is possible to separate the two.
So, so the scenario is
And-
we wait for the EIS.
Yes.
But that is not necessarily just waiting for the EIS. It could
The-
immediately kick off the permitting process.
The normal way it would work is that the Section 10 and 404 permits would be processed with the Corps as lead federal agency concurrently with the major development CAMA permit application, where Division of Coastal Management is the lead state agency. Once that final EIS is out and the 30-day comment period has passed, and David would then be getting with the consulting firms who've been working on the town's behalf for years on this, and submit a final CAMA permit package
For
to go along with the federal package.
For clarification, I think your question is, after the EIS is issued, there is still a 30-day period for public comment, and then a period beyond that where the final agency decision is rendered. Am I using the-
Yes, in fact, there's a significant time period, yes. You will
Okay,
have
so there's
the,
at least 30 days.
yeah, you'll have that 30-day.
Where the permitting process, where the application for the permit would not start.
Correct.
Okay.
Well, with a
kinda-
caveat,
you kinda-
and David, you may want to chime in on this. I don't know if Doug Huggett would,
He's not gonna accept it because their clock starts running.
right. And
That's
so
why.
Huggett he's with the Division of Coastal Management, Major Permits Coordinator. I think he has indicated to the town that they do not want to begin officially processing the major development CAMA permit until the EIS process is fully complete.
That's right.
But the EIS process is separate from what the feds call the ROD, the Record of Decision process, because that is their actual permitting process. What I thought Commissioner Freer might have been getting at is it might be possible for the town, if it was so inclined, to not formally start the CAMA permit process until the ROD was issued even on the federal permits only.
But
that
that has been my, that has
would be
been
very
my,
unusual.
well, that's been my understanding of the guidance, coming
From
forth
Huggett.
from Huggett, and the question I ask in my mind, why in the world would we make a CAMA application whenever we don't have a record of decision that is basically the capstone on the federal permit?
Yeah.
I mean, that's,
Well,
I
now
mean,
what-
I'm sorry if that's too
No,
logical.
I think that, that's
Hey, we're
a,
talking about the federal government, so
but that's a good question. I think we can get that clarified, but the federal official I spoke with this morning indicated that the two presumptively could and would run in parallel. But
At
he's
the
not
end.
Doug Huggett.
That's right.
And so we may want to get clarification of that.
But that permit for CAMA would not, permitting process would not begin until the EIS was issued and completed.
That's right.
Yes, at a minimum, the EIS must be published in the Federal Register and the 30-day comment period has to unfold.
That's right.
Yeah, when you use the word concurrent, that kind of.
Well, and I will endeavor to clarify that, and David, you may want to as well. But what Mickey Sugg of the Corps told me this morning is that once that 30-day time period expired, both could proceed concurrently under the normal, it's called the 291 Joint Memorandum of Agreement
The
between
ROD and
the Corps and CAMA to do these things together. I mean, that generally is what happens when a project needs both federal wetlands or Section 10 permits as well as a CAMA permit. There is, I think, a sort of logical point at which the board may want to reassess what it does next once that FEIS has issued and the comment period has passed, because at that point you will know what everybody and his brother, for the quote, supposed final time, has had to say on the matter. Obviously, at the same time, I've been trying to monitor and track the federal litigation that is ongoing in connection with the Ocean Isle terminal groin, where the Southern Environmental Law Center, representing North Carolina Audubon, has sued the Corps and the town in federal court, claiming, among other things, that the EIS process is defective in its economic analysis as well as environmental impacts analysis. One of the issues being raised by the Southern Environmental Law Center on the economic analysis is generic. In other words, it applies to all the terminal groin projects. And while it's more complicated than this, in a nutshell, the alleged deficiency is that when an economic analysis is being performed, the Corps and its contractors are using the total assessed value of shorefront properties that are at risk as part of their formula. And the argument by the environmental groups is that these terminal groins are at great cost and expense to local governments, and that relative to that local government, the more appropriate economic analysis would focus only on the property tax income stream. That, in other words, give a specific example. If you had $1 million beach home, the tax rate is whatever, 0.06, the annual income to the town would be $6,000 and change from the ad valorem tax assessment. And the enviros and their consultants are saying that's the number the town ought to be looking at, plus some multiplier for how much the people would spend, you know, at local stores, et cetera. And that would be a much, much smaller number than $1 million, which is the at-risk value being used in the Corps' modeling and calculations. And their point has been affirmed by Professor Andy Coburn with, of all ironic things, Western Carolina University. But Western Carolina has a fairly credible coastal program. And Coburn has written a paper that is already in the documentation that SELC is submitting to the federal court, making that very argument among others. And the point being that the town needs to do its own cost-benefit analysis relative to the true cost to it versus the benefits to it as a public entity, because there's a fundamental provision in state and federal constitutional law that, in a nutshell, says it's against the Constitution emoluments clauses for a governmental entity to spend a bunch of taxpayer money for a primarily private economic benefit or gain or protection. Now, I think there clearly are public health, safety, welfare benefits tied to the terminal groin as well. And, you can just read the purpose and need statement and know that, it's in the town's public interest to try to protect all structures, whether they're publicly or privately owned. But aside from the constitutional argument, which probably doesn't have any merit in and of itself, it does help highlight the argument that is the economic analysis and modeling flawed or not, given the way it seems to rely heavily on private total property values as opposed to a different analysis that focuses on actual income gains or losses to the town and actual impacts looking over a period of time. For instance, while it's a little bit cold-hearted to say if you happen to be the oceanfront property owner at the time, if Mother Nature does you in, the row behind you will suddenly be the $1 million oceanfront property down the road. There's going to always be, an oceanfront mean high water line with some form of a beach under, quote, natural conditions. And of course, one of the fundamental arguments the environmental groups are litigating is that hardening the shoreline ultimately reduces the net positive amount of beach available for a town or a community or the state as a whole. Whether that's true or not is beyond my ability to fully comprehend, but there certainly are a number of studies that point out and this issue is analyzed in significant detail in the DEIS, the downdrift impacts potentially associated with any terminal groin or jetty type structure, depending on how the offshore and nearshore sand transport systems operate. I don't see that as in and of itself a big adverse impact issue in this document. Others may disagree. An issue that I think is also one that has been highlighted by some opponents and the environmental groups is that there are abilities to take other less adversely impactful actions, including continued renourishment, and also, and it's interesting to look at aerial photographs over time on this, and they vary from inlet to inlet, but the alignment of the inlet channel often has really significant impacts on where fillets of sand accrete versus erode. And whether the hand of man can impact that or not is another thing. But by definition, the environmental groups oppose for the terminal groin for Holden Beach at Lockwood Folly Inlet for the additional reason that if you're trying to manage the inlet, it's on the wrong side of the inlet potentially. The argument would be because it's on the downdrift side. Now, there's plenty of people with more expertise than I have who would argue the contrary, but that is one of the points they try to make. For purposes of trying to give this community and this board good legal advice, I think the fundamental point is just real simple, and that is the environmental groups have sued Ocean Isle in federal court, and they've announced their intent to do so for Holden Beach as well, if and when there's a final end to the permitting processes here. Whether they would follow through on that, who knows? I don't think this intrudes into confidential communications because it's basic generic information, but in those kind of lawsuits, you can't sue for damages. It's not like the town or its board would be liable either collectively or individually for some sum of money that would be sought in federal court, but the cost of defending it is real, and the potential for a federal judge to order both the agency and, by definition, the defendant named town to do certain things or not do certain things is very real. And that, of course, is a difficult factor to quantify, but it is a very real factor. The other potential litigation would be in connection with the issuance by DCM, the Division of Coastal Management, of the CAMA permit. Both CAMA and the North Carolina Administrative Procedures Act contain provisions that allow third parties to challenge the issuance of those permits. And under a set of circumstances that has grown based on amendments to the law that took effect 5-10 years ago, if the agency is found to have not acted, quote, rationally, costs and attorneys' fees can be assessed against the agency. I am not aware of any case in North Carolina where any portion of that has been assessed against the permit holder, which is the position the town would be in. So I think that risk is limited to the agency and not the town. On these bullet points, the fact sheet, the record of decision, I may not have been as clear as I should have been that the record of decision is the actual permitting decision on the federal permits. And I think actually I've maybe written this a little bit less precisely than it should be as to the question, and David asked it, that we'll try to get more clarity on, which is whether the CAMA process runs concurrently with part of the federal process before the record of decision or sequentially. And we'll find that out for sure and let the board and thus the town know. Another key issue is this, the terminal groins. It's important to realize that, you know, by very language in Senate Bill 110 and the subsequent various amendments or additions to that legislation, this is a grand experiment. So all of these are pretty much plowing new ground for the regulatory agencies and the communities. Yes, there are other states that have experience with various similar structures, but they are, with the possible exception of some areas in South Carolina, it's a very different environment in terms of the way the North Carolina Outer Banks are set up and the dynamic nature of those inlets that are poked, you know, that storm events and other weather and tide events have created over the years and decades and centuries. It is sobering indeed to look at some of those aerial photographs over time, and an area that I think is worth, from a technical side, more research or investigation by this board is what happens if there is a really serious major category hurricane, and what are the impacts depending on, quite literally, the angle at which that potential storm event interacts with a terminal groin. In other words, the net effects could be very different depending on how the storm aligns, you know, with its clockwise motion relative to the alignment of the groin. And I think that's an area where I at least have not seen as much information as I would like, and I'm not sure it exists. And then additionally, you know, it's sort of appropriate by analogy to note, you know, the CAMA oceanfront development setback provisions are based on annual erosion rates times 30. Why do you think they picked 30? Well, you can speculate, but general consensus is because that was the length of the standard mortgage that a person or property owner would have. But it's worth keeping in mind that that means that essentially, if you look at it very bluntly, the CAMA program almost anticipates that the home might not be there in 30 years, or 31 years, rather. You know, you have these setbacks based on this 30-year time period, and a similar 30-year time period is part of the analysis in these groin documents. And, but it's interesting to query what happens if the erosion rates or the inlet continues to prove to us that Mother Nature is more fickle and powerful than we might expect, and it gets end run or potentially end run. And are there then additional either short or long-term costs or permits or modifications that would have to be considered relative to that? And I think that's appropriate. Interestingly, both Noel and I have served on the board of directors of the North Carolina Coastal Land Trust, and one of my favorite sayings during board assessment of various activities is that forever is a long time. And I make that point here that it's I think, worth this board's while to be thinking in terms of multiple decades periods of time and what is best relative to not just the short or medium term time frame, but the longer term time frames. And those are difficult issues. But the groins are set up to have a particular life expectancy. And just as it's worth thinking about what happens with a solar farm at the end of the life expectancy of the panels, which do have hazardous waste in them, what's the end game for a groin project that has a certain life expectancy? It's certainly better to at least think about those issues to some level on the front end rather than the back end. The related activities here is an area where David is a wealth of knowledge, and Holden Beach, as well as many other communities, are going to continue to have to struggle / deal with issues such as the shallow draft inlet permit that currently is in effect. What is the town's long-term relationship going to be with Oak Island? How are these local governments going to try to interact with the county and the state? As federal funds shrink, what are the other possible opportunities available to this community and others? And how will the community at large react to a structure like this, both in terms of the acquisition of easement interests for the structure itself, as well as in connection with the defined renourishment regime that's part of the analysis. My major long ago in a galaxy far, far away at Carolina was economics. And, you know, the standard running joke with economists is, well, tell me what you want and I can fiddle with the assumptions to get you the answer you want. And you have a set of assumptions that by necessity had to be, quote, invented for these models to be run and these analyses to be done in this draft and final environmental impact statement, and very similar processes that are being done for the other terminal groin processes. But I think it's appropriate for the town to at least consider trying to tap into its own set of, quote, second opinion expertise, not just legal. And obviously, money doesn't grow on trees, but there are people thinking about these things bigger picture-wise, and in terms of the long and middle and longer-term perspective, it's not too soon for the town to begin thinking about those in terms of inlet management as well as shoreline or beach management. Obviously, we don't have the NICE case to worry about anymore, but, you know, there are some potential ramifications of NICE here in terms of, again, if you have a structure that is literally with public money kind of creating land in a certain area and possibly taking away land elsewhere, the better your engineering analyses get, the more potential there is for some third party to feel like their ox has been gored, and whether that turns into a claim or not. A good example would be, you know, when the Corps engages in various forms of flood control within a river system, there are reported cases where sometimes the people who end up getting more water as a result do find ways to have valid claims against the federal government for the different changes to the system. I honestly don't know where that potentially goes in, if you will, the legal history or history to be made regarding terminal groins, but if we do have a number of these projects over time in North Carolina, I can guarantee you that some creative lawyer somewhere is gonna try. It's just, again, something to try to factor in. And the good thing is, as is documented in these draft environmental impact statement, a terminal groin is susceptible to being modified. And you can either, you know, have gaps made bigger or smaller and heights changed. And, you know, if necessary, as called for by the statute, removal, depending on the results of some of these ongoing studies. Ongoing data collection is a part of the required statutory process. It's still a little bit early to know what those costs are going to be over time, and if the federal or CAMA folks will change what they do ask be done. And you can guess who will be asked to pay for it, the permit holder. Lastly, you have the issue of the property interest as well. Well, I mentioned that once before, but I think, again, the groin easements are for an actual structure, which is different than the beach nourishment easements. So once you have a specific project defined, there will be property owners, you know, who are specifically targeted for either voluntary easement acquisition or condemnation if necessary.
Clark, can I input something?
Yes.
Specific to the beach renourishment easements necessary for the Eastern Reach project, anticipating public feedback or those property owners' calls in response to getting that. I think a key component of that is to state specifically in that easement that it is limited to beach renourishment and to limit its ability to be used for something like a hardened structure. I also think, in speaking with David, that one, that saves the town time and money collecting those easements back, because it's the number one question that I'm going to get when people receive that document. But also, from a permitting standpoint, we may really have to have three very specific easements for each of the permits that's pending right now. Or is that consistent with our previous discussions? Clark, I know we talked about that too.
Yeah, and there's again, as we go through these unusual projects, it's new for these agencies as well, and sort of the timing of when those are required to be in final form has been an issue where there's been some back and forth discussion. But from a simple legal issue, the question is, are the people going to cooperate or not? And is the town willing to initiate condemnation proceedings if they're not? And that kind of gets back to, there is no requirement that the community that there be a referendum or that the community be asked to vote one way or the other. But there are going to be some specific shorefront property owners that are going to be, the town is going to have to interact with. And I do think it's important to recognize that that interaction is different than for nourishment project. You know, it's different both legally and just in terms of, you know, a structure versus just sand potentially adding to the beach. But of course, even that has its own issues because publicly funded renourishment, if it raises property, that property is then owned by the state of North Carolina. And in a technical sense, every renourishment project that's successful divests shorefront property owners of being, in a technical legal sense, shorefront property owners anymore. There's a strip of land between them and the ocean that's owned by the state of North Carolina. And that issue is dealt with in the easements by granting them rights as if they were, quote, littoral property owners. But it is a different property right. That's more than enough. And I'll hush. And if there are any specific questions, I'll be glad to try to answer them. It's my understanding the board has directed me to try to produce a written product for them that they would be able to have and digest sort of at the same time that the final EIS is published. Does that sound like a fair statement there, Mike? Or?
Yeah.
Yeah.
Yes.
Okay.
Yeah, it's obviously very complex, and thank you very much for the information. And there was a lot of discussion, obviously, about, you know, how to go forward, but,
I would like to make one more comment. The last bullet, I think that while there needs to be some further discussion about exactly how this is done, I think the idea of a standing committee or information gathering entity is a good one because that allows, you know, board members may come and go, but, and David, you know, despite him being here a good while and having a great deal of, you know, we all come and go and we can all get hit by a bus tomorrow. And I think having a sort of standing committee or board that looks at all these pieces of the puzzle and tries to give the town, you know, the benefit of information gathered over time that will be available to guide it and future board members in making future decisions is a good concept. And I would encourage the board to consider bringing in people with varying points of view, you know, at workshops or to make presentations, whether it's ranging from opponents to proponents to professors, you name it, engineers. I think getting a wide range of input, which is already happening, and some good examples of that already have happened here and with the, you know, the inlet and beach management organization entities, but we need more of that, not less of it. Thank you very much.
Thank you, sir.
thank you.
What's the pleasure of the board? Next item on the agenda is an adjournment.
Recess.
All right, you want to recess?
Recess.
Recess.
Well, to recess, you gotta have a time and date certain, if I understand the law.
I believe we agreed that our recess would be until Friday, this Friday, the 19th, is it, at 1 PM in this location.
Is that your motion?
That is my motion.
Is there a second?
Second.
Any discussion? All in favor, say aye.
Aye.
Thank you very much. We're adjourned.
Recess.
Recess.
Recess.